Patrick mentioned, there's a great history to the Fair Trial Free Press Conference that we're proud to carry on with the great support of Albany Law School. This was actually created under the aegis of New York State Chief Judge Charles Bartell in about 1971, I believe, with the support of now non-existent organizations, including the New York State Society of Newspaper Editors, the New York State Associated Press Association, Sheriff's Association, the DA's Association, the Public Defenders. A lot of groups came together saying that we need to have some sort of a forum where we can discuss those moments where the First and Sixth Amendments seem to conflict. And the hypothetical format was something that seemed to be ripe as a conversation opportunity. Many of you perhaps saw Fred Friendly doing this on public television, Friendly seminars. Fred Friendly was my professor at the Columbia Journalism School. And I can tell you that this kind of seminar for lawyers and journalists together was just a dynamic experience, which he ran at the Ford Foundation for many years. And it seems like this kind of format really works. So we've had a great time doing this. And over the years, we've had some wonderful hypotheticals with great participants like our faculty today. My partner in crime as co-moderator for these many years has been Al Rosenblatt, who sat on the Court of Appeals with Chief Judge Judith Kaye, who was the great advocate for fair trial free press and would always attend and have some interesting remarks at the end. Anything you'd like to add, Al, as we get underway?
Well, just briefly to welcome everyone here. Those of you who do not know about the history and the mission of the Fair Trial Free Press, it began, as Rex said, in order to bring together in a civil forum, in a civil arena, two distinct institutions, both of which are fundamental to our way of life and our Constitution. But institutionally, they occasionally collided. And we thought the way to make the collisions not destructive, but useful would be to create hypotheticals, bring in folks like they're on the panel here today, and with that have a civil discourse so that we could understand in each other's viewpoints. And it's turned out to be very, very good that way, very civilized. Rex and I are sort of provocateurs, but before using the word provocateur, I thought I would take this out and just put in provocateur define, and it came up agent provocateur. And two things happened that surprised me. One, agent provocateur is a lingerie line. You're nodding, I guess I didn't know that. And secondly, agent provocateur is to induce someone to commit a crime. But we have neither of those things in mind. We're just going to be up here and play it straight.
Right, absolutely so. But we have warned our panelists, though they have seen the hypothetical in advance, there may be some surprise questions. To wit, in the conversation in the hallway, Judge Lindley was making the point that the judges on the bench often don't have the expertise on particular issues that specialists in First Amendment law, for example, might have, because judges have to hear so many cases on such a wide range. So I might just ask one of our specialists, Diego Ibargüen of Hearst, is there anything more you'd like to say by way of background about Sullivan, since we're going to be talking about the potential erosion of Sullivan and the implications for that, beyond what Clifton just offered us? Is there anything further you'd like to say by way of background?
Yeah, I think Sullivan is really one of those fascinating cases that you could probably spend weeks and weeks in a daily course talking through. And I guess I'll recommend anyone who hasn't read it, Anthony Lewis's book, Make No Law, which really is probably the best way of understanding just how important that particular case is in that particular moment and what it has meant in the development of defamation law and the defense against defamation claims in the now 60 plus years since it was decided. I think the key thing that is important to remember or think about in terms of Sullivan is what it establishes, and that's this actual malice rule. And actual malice, of course, exists in state law in a slightly different way than it actually is developed in the Sullivan case. The Sullivan case is actually setting up a totally different standard in a fairly narrow context. Public officials, not just public figures, not people who have chosen to make themselves part of public life on a particular issue, but elected public officials who sue for defamation, claiming that their reputations have been damaged. They must establish that the person who made the allegedly defamatory comment, which has to have been false, of course, can't be true, that they did so with knowledge of the falsity of that statement or with a reckless disregard as to the truth or falsity of the statement. And I think that's something that often gets lost in the thinking around Sullivan and the way that it gets applied, the way that it gets thrown around. And then over time, what has happened is the Supreme Court in particular, has developed a much broader sense of when actual malice might apply, because it's a pretty good rule. And it's a rule that tends to favor transparency and discussion about things that matter to people. And not everything that matters to people is uttered by people who are elected to public office. It's often done by people who have become public figures for some other reason. Even using the hypothetical as an example, a Big Ten coach, football coach, might well be a public figure in a number of contexts where the public wants to be able to talk about that person. If you think about who ends up on trial for various types of crime or civil complaint, they're not always going to be elected officials, and people want to be able to talk about those things freely. So the key thing to remember is that it started out as applying to public officials. It has been expanded to apply to a far broader set of circumstances where someone might well have injected themselves into the public debate, or perhaps have found themselves in the public debate without necessarily choosing to be there.
Anything else, Counselor? I might add, we're on this panel. Alan Lewis is with us from Carter Ledyard, who is the chair of First Amendment and Media Law there. Would you add anything to that broad description?
One thing I find interesting about Sullivan is that it involved a state statute under which there was no fault element. There was strict liability for false statements. And of course, there's a middle ground between strict liability and actual malice. New York has it without needing to interpret the Constitution and to cull from it fault standards. When one sues the media, anyone involved in information gathering in New York, in a case called Chapadoe, the court required that the plaintiff demonstrate gross irresponsibility, a fault standard greater than negligence, just slightly short of actual malice. So, it's easy to sort of understand the Supreme Court's great concern about the way the statute that they were faced with in Sullivan worked, but going all the way to requiring actual malice in lawsuits against public officials was at the far end of the spectrum. They could have gone somewhere in between. And in reading Sullivan, I am sympathetic to the argument that this was policymaking, not truly an interpretation of what the Constitution requires. As critics of Sullivan have pointed out in the years since, the tort of defamation coexisted with our Bill of Rights, the enactment of the First Amendment. Defamation lawsuits went on against public officials and those we would today call public figures without having to prove actual malice. And so I think there is some basis for criticism of
and the states are free to enact sure everyone out there knows, but that's one instance where states can do things that go beyond the ken of United States Supreme Court interpretations of the Constitution. States can do it by statute.
So in our scenario today, we envision this all taking place some months after a Supreme Court decision in the case of O'Malley versus SportsDirt.com, presumably, in which a former Big Ten football coach sued an online news outlet. So SportsDirt published a long investigative piece on new allegations from a range of named and anonymous sources who detailed misconduct charges, including recurring emotional abuse and physical violence against players during the coach's otherwise celebrated 2 decades career. And the decision, the new decision in our hypothetical, stressing, of course, that this has not happened in the United States at this point, pruned back a significant element of Times v. Sullivan from 1964 and its progeny. So the new court majority now concludes that the coach's leading a quiet life in retirement for more than a decade meant that he was no longer a public figure at the time of publication, and therefore the First Amendment requirement of proving actual malice was, in the words of our hypothetical court, too high a bar for a plaintiff whose reputation has been shredded by allegedly incompetent journalism. So here we go to our main story taking place in Kendall County. And Al, I will let you pick it up from there. Are you ready?
Well, okay. I would ask the media people, what if this case became law and Sullivan against the Times was undercut? What would happen in the newsroom? What would the discussions be like? Let's start with Casey.
I am lucky in the sense that I work for an organization that does have the resources of an Office of General Counsel that includes Diego, who I work most closely with of any of the fine attorneys there. I would imagine that within the Hearst newspaper group, the alarm would be loud and long, telling us exactly what the implications are from this Supreme Court decision. I would imagine that fine media organizations such as the one that brings us here tonight would probably also organize a kind of crash educational courses for various media organizations on exactly what the implications are of this type of a decision. I would imagine that at smaller news organizations, far from the potential aid of organizations like that, there would be considerably more confusion, considerably more chaos in imagining what the decision might mean in terms of ground level reporting on controversies within a city council, a former mayor who gets arrested for DUI, for example. I think that it would immediately create more discussions around whether or not someone who has been in the public eye remains in the public eye and is therefore a public figure under this, this pruning back, this diminishment of Sullivan. In other words, the umbrella has gotten considerably smaller. Are we going to get wet?
So you folks are become a lot more vulnerable. So let me ask Jim Roberts, it's going to be easier to sue you. That's the bottom line. So is that going to restrain your investigative punch, or what? How are you going to deal with that?
Well, in our case, the Peekskill Herald, we're a very small, local, nonprofit startup. We don't have any of these kinds of resources. So what we do now, we have a pro bono law school that's willing to work with us. And I have to depend on my 35 years of experience to try to make a judgment what kinds of things have to be run by the law firm before we publish. So the reality is this is so high above the level that we're at. I'm not even going to be aware of things like that. I have to know that this is dangerous. The lawyer's got to look at it.
Well, you get a scoop that something bad is going on among in the case of a former public figure. Do you say to yourself, "Oh, I got to be super careful now because now I'm vulnerable"? to a lawsuit.
No, like I say,
that doesn't
No,
enter into it.
I always have to be super careful, and I can't expose myself in the publication. So again, this is a distinction above the pay grade of anything that we're doing.
Well, I have to tell you, this is why I love Rex Smith. I don't remember the circumstances, but I was in a car years ago with Rex, and a call came in which some very prominent public official, the state police, were doing an investigation that he was assaulting his spouse. I just happened to be in the car with you, and it was just an amazing coincidence. And I saw at work, if we had people of the integrity of Rex, the questions he was asking and the care that he exercised before he decided to go public with anything. I don't remember when and whether you went public, but what impressed me so much was the process that you introduced before you even began to unearth and publicize all that. Do you remember?
I was scared to death. No, you have to, because you in a circumstance where you don't have counsel handy, where you can't necessarily, even if you can call a general counsel's office at a corporate parent, you still need to do the due diligence first, right? You need to get the reporters to ask the right questions, which is why there needs to be some coaching in advance, why editors get jobs like Casey's only after they have had some experience with this kind of thing and have gone through a few rounds with Diego Ibargüen and so on to try to do this. Yes, this happens all the time. I think that was probably a case where the mayor was assaulting his wife.
No, I think this was earlier. This might have been earlier than that. And I think this might have been one of the cases that informed our hypothetical here tonight.
Oh, I know what we're talking about.
That's
Yes.
right.
Could I interject with one point that I
Please.
think ties a few of these together? It isn't, actual malice is not a defense against bad journalism, right? And it's not a sort of an excuse to do sloppy journalism. And that's something that I think also gets lost in the mix occasionally. And I speak here as not just a lawyer for news reporters, but also as a former reporter myself. Good reporting and good legal defenses really go hand in hand. The kind of work that I know Rex and Casey do, that I'm sure Jim does, is 9 times out of 10 going to alleviate the risks. Mistakes happen. That's really where actual malice serves its greatest purpose as a defense. But good journalism is going to lead to good legal defenses.
You know, those of us who are amateurs in the newsroom, I've never been in a newsroom, we've heard the phrase two sources. Is that a fable, or is it a rule of thumb, or does it have any utility at all? Can I ask the media people, or am I just misguided on that point?
I wouldn't ever run a story with just one source.
If it's reliable, you would not.
I would not, just one source. No, I need.
Really? Isn't that interesting?
Something like that.
What about Watergate? Would you have,
Two sources.
Well,
You
they
need,
had- they had a lot more.
you had more than one, more than Deep Throat?
what if one of the sources was, the Pope or
If
Abe
you wanted to
Lincoln?
go on the record, sure.
Oh, I see. We're talking about undisclosed sources, of course.
What if both sources are bad?
And what if one source is the only witness to the wrongdoing you are reporting on? In other words, in some cases, one source who is a credible source who you have reason to believe should be enough, especially if they are backed up by not another source, but by documents.
Which brings us to our hypothetical. This is why let's get into this
Wait, I
thing
think
here.
Alan
because
wanted to add something here on that.
So there isn't really a talismanic effect of cleaning a number of sources. Surely courts look at all of the facts, and the more sources a reporter had or what they published will, tend to push back against a conclusion that the reporting was reckless as to the truth or falsity of what was reported. But it's certainly, one can envision a situation in which a reporter has more than one source, but in addition to what those sources are saying, there are reasons to have serious doubt about what's being reported, which makes it incumbent upon the reporter to do more investigation before publishing something that's going to savage someone's reputation. So more sources is great, but the media shouldn't rest on the number of sources as the sort of the moment or the time to go ahead and publish something. the degree of an investigation that's necessary is always quite specific to the particular story.
Fact. Are there any theological experts in the room? I'm not a theologian, and I really am not suited to talk about that at all. But in some research I was doing, I ran into the two-witness rule. Have you ever heard the two? It's, I think, biblical, the two-witness rule, that before anybody can get convicted, you need two witnesses. It goes back, I think, to some biblical tract. Mr. DA, is there anything like that in your office?
Well, listen, we talk about sources, and that's certainly something that we deal with every day as a district attorney or an assistant district attorney. And when we evaluate sources, we talk about reliability and the importance of reliability. And that really, I think, is a key concept, when we talk about sources. How reliable is the source? And when we talk about getting search warrants and a judge reviewing a search warrant, especially with confidential sources, they want to know, can we show that this informant is reliable or not? And if they're not reliable, the judge is not going to sign off on the search warrant. So I think that really is important, and it's something that we evaluate every single day in a district attorney's office from that perspective. And law enforcement does it as well. We have to certainly evaluate every single witness statement and whether it's reliable. And that's absolutely an important concept when we talk about law enforcement and when we talk about criminal prosecutions.
Reliability for warrant purposes not being necessarily the same as reliability at trial.
Correct.
Yeah.
I would just say if we in the court system had a rule that you needed two independent witnesses, it would be hard to convict a lot of sex offenders. There's a lot of people doing hard time in New York State prison and prisons across the state, convicted based on testimony of a single witness. We've had that argument made before. Judge Rosenblatt, you probably saw it as you were an appellate judge, but I'm an appellate judge, and we see many cases where there's one witness, the defense lawyer says one's not enough. The state of the law in the state of New York is, yes, well, it depends on how strong the witness is. So people are being incarcerated for long periods of time based on the testimony of one witness. So it would surprise me that the press would need two to go to print a story.
Interestingly, the judiciary has an advantage here that isn't all that well known. It should be well known. It's no secret that when dealing with an undisclosed informant in the judicial arena, the DA can bring that informant in front of the judge in a sealed record in a private location, and that identity will never, ever be revealed. So that's something that, have you ever been in there? Have they come before you with an informant?
Darden hearing, we call them Darden hearings in New York. And
you keep the record sealed?
As a trial judge, I did Darden hearings. On appeal, we don't, but yeah.
Is there a parallel? Can the press do anything like that? Bring them before the great editor in the sky?
Well, there are shield laws. There are shield protections. There are, New York has a fairly strong journalistic shield law, which protects from compelled disclosure of the identity of sources. It's not quite as reaching into the infallibility levels of the judicial process, and there's good reason for that, right? Different states have different levels of protection for journalists, and there are arguments about the degree to which there's federal protection. The famous case at the federal level, Brandsburg v. Hayes, ultimately concluded that there wasn't a constitutional protection against having to identify the source of information in a criminal court context. But that case, it's another fun one to read, and there's been plenty written about it, has led to another 40, 50 years of controversy over what exactly it meant. And states have gone in a number of different directions. To your point at the opening about where states can do things differently from the federal government, many states responded to that by passing their own state shield laws, New York among them.
Shield law. Rex, we want to talk a little bit, can we take just a tiny little departure and talk about the shield law? And what that connotes, was I'm not sure everybody knows the shield law and the power of the legislature to enact one. Anybody?
We're often cautioned by counsel that you can't use an unnamed source as both a sword and a shield. That when you use an unnamed source to get across a point, you'd better be sure that that source understands that you will protect their identity insofar as you possibly can. And we have had occasions where we've told a reporter, pack a toothbrush when you're going into that courtroom. You may be held in contempt for refusing to reveal your source if that's your intent. So that is, we know that we're not totally protected, and certainly on the federal level, where you have an administration now that is actively seeking out sources of leaks, and where the Justice Department in Washington has dropped the provision that central justice has to approve any effort to uncover reporter sources or to subpoena a reporter, I believe. Isn't that what the new standard is?
Yeah, this gets into some of the weeds where there are a lot of unanswered questions, both about what exactly is permitted and not, and what the DOJ has said it will or won't do. But the quick answer is that the recent moves by the DOJ have moved from a fairly restricted use of subpoena power by the DOJ to obtain information from reporters to something that is a little more like what existed at the tail end of Eric Holder's time as Attorney General, which you may recall involved a series of leak investigations and subpoenas of journalists for information on confidential sources. To Rex's point, and I guess I'll just tie this back to what I said before about good journalism providing good legal defenses, relying on confidential sources ought to trigger a great degree of skepticism in anybody, right? You ought to wonder why it is that this person is unwilling to be identified and connected to whatever this meaty information is. And I think that applies. I think you probably both feel the same way on the law enforcement and judicial sides. For journalists, that ought to be a signal that there may be something else here. It doesn't mean that you won't grant confidentiality, which is a promise, a contract of sorts that you make with the source. You have to understand what the parameters of that contract are, and you have to understand exactly why you're giving it. That requires a lot of work.
So if you would, can you just tell us maybe in 2 sentences, if you were to write a shield law that you thought to be ideal, what would it say?
Well, I'm a little bit of an absolutist, so I would argue that journalists ought never to be required
Never.
ever. However, as a realist, I'd say that there has to be some sort of a qualified basis where you would have the journalist's privilege against testimony being the standard, the expectation, and then there being circumstances where, under the right circumstances, a fact finder could
So
determine.
the DA now, you learned that the reporter has a confidential source that someone's about to blow up the Empire State Building. And you want to get that reported before the grand jury and say, who told you this? Because we want to check it out. And he says, wait a minute, I'm not talking, I don't have to talk. Where do you fit in on this, Mr. DA?
Well, certainly when we evaluate a circumstance like that, we're talking about public safety.
Right.
And public safety, certainly from our perspective, is always going to be paramount. So there's always going to be that clash between the press and law enforcement. And, whether protecting the public as a whole is paramount to the confidentiality is really the question.
So, Your Honor, they're before you now. The DA says, I want identity. The press says shield law. They're coming into you for an injunction or to sign a subpoena to the reporter to get in front of the grand jury. How do you rule? What goes into your thinking?
Yeah, I think, as Diego said, there's no absolute privilege there. And we balance the harm to the community and the harm to revealing the source. And I think most judges would err on the side of public safety. It's a fact in New York State, judges have to run for re-election and shouldn't come into the
years earlier, in which the county sheriff, a guy named George Graff, went to the home of Smith's call, in which a woman can be heard saying her husband was drunk and had tried to strangle her. There is no record of any arrest. No charges were brought. Tim and Karen Smith, the former county executive, and his wife are now divorced. The Courier's story states that all three of the parties in the case, the Smiths as well as the then sheriff, would not comment. Tim Smith, who since leaving office has gone back to his quiet career as a real estate lawyer, says in response to the newspaper's query that the audio is fake, that he's the victim of an obvious fraud. The first thing I want to ask actually is to the DA. What do you do? How do prosecutors and the police officers who provide information to you typically assess whether to make an arrest or prosecute a case in scenarios involving domestic violence? And what do you do when the complaining witness suddenly no longer complains? I presume
very, very difficult. We have to understand and feel comfortable that it's a matter that we can go forward on, and that we can prove beyond the reasonable doubt, and obtain a conviction in the end. But when a victim recants, it's a very difficult situation. Certainly we're talking about the future safety of the victim, and we're also talking about not re-victimizing them and forcing them to go forward with the prosecution. So really, it does involve a lot of work that really is kind of a support structure. We want to support the victim. We want to encourage them, but not push them, obviously, to cooperate. And that's important, because if we push them, we can re-victimize them, and we don't want to do that. So it's a very difficult circumstance. We see it all the time. And, it really, really involves taking into consideration future safety, but also taking into consideration, the victim themselves and what is going to happen to them if we do not treat them, in a manner where we're not going to re-victimize them. So it's very difficult. It really, truly is.
so. Mr. Editor, you've just heard a nuanced and sensitive explanation from a prosecutor as to why this case didn't go anywhere, but you've got a hot reporter down here who's come up with a story with tape recording. And he also has a source, apparently, who knows, but a really good source, who says this is what happened. And let's add to the scenario, perhaps the former sheriff and the prosecutor might be on the same political ticket, having been elected together.
Yes, that happens.
That happens. Does that influence your thinking about whether you should publish here? The fact that there were no charges brought, there is no documentation to back this up, but you've got a tape and an unnamed source. That's a tough decision, isn't it?
It is a tough decision, and considering how many both law enforcement figures and, in the case of the former county executive, an attorney is involved, that would definitely make my antennae tingle more than the usual story would. Just to respond to that, the Times Union has a policy that we do not identify victims of. How do we put it? I think it is gendered abuse. In other words, from workplace sexual harassment all the way up, of course, to rape victims, as with any crime victim. We will not name them. There are, of course, exceptions to that, such as when victims come forward and want to be identified, or in a case like this, where it would be impossible to report out the story without, at least by implication, naming the victim as, or the alleged victim as the former county executive's ex-wife, now ex-wife. But in terms of whether or not this would be a story that would be one that we would see as necessary to alert to bring to our community, to our readership, there is no question that it would be an important story for us, and a key story, one where, of course, we would want to be careful. As with anything, there is the specific case at hand here with individual alleged perpetrators and victims. But more important than that to our readership is the system that sort of surrounds the individual case. And it's something involving county leadership, county law enforcement leadership, and, as you mentioned, a prosecutor who might be influenced by these political considerations. That is a corrupt, superstructure around this specific incident that we would be derelict in looking away from.
Just to give you a sense of how convoluted some of these things can get and how you can't apply a strict rule to some of them, I recall some 3 decades or so ago as a reporter covering the courts, when I was compelled by an editor to not name a defendant in a first-degree rape case that I was covering because he had assaulted his wife, and to name the defendant would thereby identify the rape victim. And that was an application of a newsroom standard that carried it just a little bit far, I would say. It was quite awkward to be reporting about a trial where you couldn't name the person on trial for fear of naming the victim. That might have been, I'm glad that I wasn't the editor having to make that call, just a reporter, just do what the boss says, right? That's difficult. And so and Alan Lewis, I might ask you, if you're representing Tim Smith, the former politician, now retired, back in his business career, a career that, by the way, is in the public eye, where he needs to have the confidence of people. He's a real estate broker. Folks need to come to him if they need to trust him. What would you advise your client in this circumstance where you've got an investigative reporter knocking on the door saying, we have tape, we have a source, what happened? What do you tell them?
You're asking me after the story is published and Tim approaches me and seeks my advice as to whether we should commence a defamation lawsuit?
You might start by saying, what would you do? What would you say to him in the beforehand? If he calls you and says, this reporter, Jim Roberts, is knocking on my door, what am I supposed to say to him?
Well, the before or after Sullivan is modified, I'm going to try to bring to the attention of the reporter, of the media, before they publish the story, all of the facts that would undermine confidence in the story. I want to create doubt, serious doubt in the minds of a reasonable reporter based on the additional information we provide to them. So I'm going to go over with Tim Smith, what else there is about this that would tend to undermine the story, present it to the media, and argue to them that if they go ahead and publish now without doing the further investigation, that the information I provided to you warrants, then that refusal to investigate further will be a strong argument in favor of the conclusion that you published the story with reckless disregard to whether it was true or false. So we're going to try to influence the story first.
Hold right there. Are you persuaded by this? Does that sound like you might be engaging in reckless disregard
This would be a dream come true if somebody actually called me back and said the story, 'cause I'm gonna get a no comment.
So it's not going to be Tim. It's going to be me
That'd be great.
writing, really, well, you don't have in-house counsel, but in effect to the pro bono lawyers who provide that to you. This
Give
is
me
going to
something
be
else.
lawyer to lawyer.
Pursue, I'll pursue it, sure, before I print anything, sure, absolutely. But if it doesn't lead to anything, then my story goes.
Russ, can I ask a question of the lawyers who represent defendants in these cases? Diego and Alan. I practice criminal law and I would not, if I had a defendant that I was representing, I wouldn't ask straight out, did you do it or not? Do you, if you get a client like Tim Smith, would you ask them flat out before we get started, is this true what they printed about you?
So he's not vulnerable to criminal
Right.
prosecution in this example. It's too long ago. Any
Right.
statute of limitations has expired. So we're evaluating his position as a litigant, as a plaintiff in a defamation case where one of his obligations is going to be to prove the falsity of what was published or is about to be published. And so before you can advise your client about the risks of undertaking this lawsuit, you have to find out what's going to be our evidence. How are we going to prove that this story about your ex-wife, that this tape recording that they claim to have isn't real and is phony? Because if you can't prove it, then let's put aside questions of fault and actual malice and Sullivan. You're not going to win the case.
Would you ask them flat out, were you drunk and did you try to strangle your wife?
I would.
Okay.
I would,
So-
because again, I'm also a criminal defense lawyer.
Right.
And if the context for this client relationship were criminal defense, there's a police investigation, I might not ask that question. But as a potential plaintiff in a defamation.
Right, that makes
case,
sense.
You have to.
Right, okay.
So in the hypothetical, Tim Smith then files a complaint with the sheriff's office, and the sheriff goes to the judge for a search warrant to search the newspaper records. Where does the sheriff come off doing this? Do we have a sheriff anywhere out here? Like, what is the sheriff up to? Or is this the fault of our hypothetical? What in the world is the sheriff doing? Getting a search warrant to search the newspaper files?
I think
What's
it's
he looking
TA
for?
Answer for the sheriff here.
Are
too.
you going to answer for the sheriff? Put on your sheriff hat, the big hat, you know, with the whole.
Do I get to make up the facts? Because
This is one element of the hypothetical that is completely true, by the way.
really?
Yeah.
What do you mean?
This is the Kansas case where a newspaper that a local sheriff got a search warrant for records that were held by a newspaper, and they raided the newsroom.
All right,
I mean-
so the DA has a policy in his office. Thank goodness. When I was the DA, we had the same policy, but I went back, a lot earlier before this young man. No search warrant is issued without the DA approving. So the sheriff comes to you and he says, I want to bust into the newspaper. What do you think?
So we're gonna sit.
What are you
down.
looking for?
We're gonna sit down and we're gonna evaluate what evidence he has. We're proof driven. We look at what the evidence is. It's a probable cause standard.
Proof of what? What crime?
Well, that's the question. What is the crime that we're
What's the
investigating?
crime?
Number one. And if there is a crime, which there would have to be, what is the evidence that we're searching this area for? What are we searching for? And is there evidence to support probable cause that this evidence is located, at this organization? And
I'm
that's the analysis.
I'm
And
still lost to what crime is being committed. Judge, they're giving you the
Yeah.
search warrant to
Look,
sign.
I don't blame the DA. They can ask for, I've had a lot of outrageous requests for relief that is wholly inappropriate. I blame the judge. The judge in that Meyer case, Judge VR, magistrate judge, signed the search warrants. They were wholly inappropriate. You wrote a book on search warrants and I read it. You under the Fourth Amendment, you need probable cause to sign a warrant that there's a crime. Under the criminal procedure law in New York State, I'm sure it's the same way in Kansas where the Meyer case was. You can't get a search warrant to search for evidence to help a party in a civil lawsuit. That's what was going on here. Now, the Kansas authorities claimed there were that there were crimes, that privacy, and there was the reporter went and impersonated somebody to get the driver's license of the woman who had a DWI and so forth. The trial court on a motion to dismiss had rejected that. In our scenario, there's no plausible charges. So I blame the judges. It is a reversible error. It was absurd. I've signed thousands of warrants when I was a city court judge.
Wow.
And you look and you see what crime is being alleged. Here, they should have said to the DA, you want to go, they went into Miss Meyer's house, the plaintiff's mother. She was 98 years old. They went into her house, confiscated her cell phones, her computers, her laptops. She died 24 hours later from cardiac arrest. They threatened to arrest her. They went into the newsroom. They took computers, laptops from the records office, and they took, it was an outrageous abuse of prosecutorial and police power. And I would not want to be those defendants in that Kansas action, which has survived a motion to dismiss and is heading towards trial.
Yeah, I think there's no question, because as prosecutors, as a DA, what are the two locations that we're going to scrutinize with a fine-tuned comb, right? One would be press organization.
Yeah.
Two would be a lawyer's office. So, the reality is it's questionable to begin with, right? So if a law enforcement agency, whether it be a sheriff or anyone else, is coming to us with a search warrant, looking to search either one of those organizations, we're going to go over that evidence, and we're going to be sure that within the four corners of the application, it absolutely meets the legal requirements in whatever state we are before we'd ever put it in front of a judge to consider.
So Judge, when you were signing search warrants as a county judge or as a
City,
JSC?
As a city court judge, Rochester
As a
City Court.
City court
Yes,
judge?
Yeah.
Do they come before you ever, now that you're on the appellate division, for search
I
warrants?
don't see warrants now. There's mostly local court under New York law, and they'd come at all hours of the night. And there's a temptation to, this judge apparently didn't read in Meyer, didn't read there was a falsity that the sheriff was before her making the application. It turns out not to be. I think that there's a temptation sometimes the judges just trust the police too much and just sign off without reading very carefully. Because they come to you 2, 3 o'clock in the morning, and you've got to, it takes a little discipline to sit down and say, hold on, guys, because they're always in a hurry. They're like, we got to get this search. We got to do this. Time is of the essence. And they get angry. You're sitting there page after page asking questions. So it's a responsibility. The buck stops with the judge. And in that Meyer case and in our hypothetical, there's no way in the world those judges should have signed those warrants. Absent probable cause of a crime.
I mean, I think
No,
that
on the way down, the DA told me, we rode down together. The DA said there are counties in which law officials get search warrants from judges without, and bypassing the DA. That's astonishing, but it goes on, and the judges are free to sign them if they want to, but of course that can get upset on a motion to suppress.
Whose impetus is that? Is it, how do you establish such a rule in your county? Because a law enforcement agency is sort of its own. You can't tell a police chief or a sheriff, can you?
Well, it's really with the collaboration between law enforcement and the judiciary. And I think most judiciary, they're reviewing these at all hours of the night and day. They want someone else other than themselves or law enforcement looking at these. And, I think that the reality is they want that. Despite the fact that the criminal procedure law in New York does not require that a district attorney or assistant district attorney have a line on an application for a search warrant that says it was approved by them and signed by them, I think most judges welcome it and they appreciate it. And because of that, at least in my county, they will not sign it unless an assistant DA has signed it in approving and having reviewed the search warrant, which, listen, it's 3, 4 o'clock in the morning. The nice thing about the way we work with law enforcement is typically we're actually involved in the production of the document. So, we're there sitting with the officer producing the document, going through, what evidence we have to support the application. So, it's very thoroughly thought through. And then, you're going to a judge who may have just woken out of a dead sleep in the middle of the night, and now we're asking them to review what could be a complicated search warrant. And I think they appreciate the fact that, you know, an assistant DA has looked at it, reviewed it, and feels that it's legally sufficient. And
To your point, 99% of the time it's cooperative and welcome by the police. But in the 1% of the time, the police could say, look, I can go to a judge and bypass the DA. The DA has the ultimate trump card. They'll say, you can go to the judge all you want with your warrants and make the arrest. I will not prosecute. Case over. So the DA has the ultimate power in that, and that's why it almost never comes to that.
Of course, the damage is already done. If the
Huh?
arrest, the damage is already done. If the arrest happens, if the materials are
Sure.
seized, as was the case in that
The
Marion,
damage is done.
case. I mean, just to play devil's advocate, I mean, we could imagine a couple of potential crimes that could have been the basis for a complaint here that might have led to a search warrant. Maybe it's something about a wiretap or an illegal recording, legal wiretap. Maybe it's something related to access to police systems, which I think was the basis ultimately that was provided in that Marion case. Those are thin, in my view, but there would have to be something like that in order for, I think, for any judge to actually sign off on the warrant. I would expect for any sheriff to present it.
So in our scenario, in the days after this happens, the newspaper sues the sheriff's office and demands the return of their equipment. Tim Smith, the aggrieved former county executive, sues the newspaper for defamation because they went ahead and ran this story, notwithstanding the good arguments that counsel put forward to the reporter who was only too happy to hear it. And the Kimball County Legislature, stacked with allies from the former county executive's long tenure, moves to cancel its contract with the paper, designating it as the official publisher of legal notices. The loss of that contract would reduce the paper's profits by a significant percentage. You might just want to say a word, Mr. Editor, about covering your own organization. If a legislature were to cancel its advertising contract with your newsroom, would you be quoted in your reporter's story?
Yes, most likely either I would be quoted or our publisher would be quoted. We have a policy that is longstanding, as you were well aware of, that any coverage of our organization, meaning any story that touches on the Times Union personnel, be they in the newsroom or any other department, needs to have the eye of the publisher on it. And happily, that does not occur very often. But in this case, that would definitely happen. In cases that involve serious alleged wrongdoing by a media organization, the possibility exists. We saw it with the New York Times covering itself. Other organizations have either tried to create a kind of walled off unit or special task force, sometimes bringing in people from outside to look at a specific topic. This is probably not one of those stories because this doesn't involve necessarily wrongdoing by newsroom personnel, because of course the editor would say we stand by our story. But in terms of covering the action of the county legislature and pulling the legals contract, that all takes place in public view. So that's something that either a business reporter or a local government reporter could cover, I think with impunity, although I'm sure the politicians would say, well, of course, no wonder you're making a big deal out of this because your ox is getting gored.
So I cut you off before, Alan, when you were talking about the case that you would bring post-publication. Are you, what's the basis of that case? Are you going to be, under the scenario that we have here, the post-Sullivan era, what kind of an argument can you make about your client being subjected to this outrageous bit of reporting by this rag?
Well, I mentioned earlier some of the other elements of the tort of defamation beyond, fault at the level of actual malice. We're in New York, so even after a narrowing of Sullivan to make actual malice not apply here, it'd still have to prove gross irresponsibility, which is a very difficult standard of fault to meet. Beyond that, I'm concerned that this lawsuit is going to be dismissed based on the fair report privilege. It's reporting about a police investigation. Now, in many, the fair report privilege provides immunity to the media for reporting on official government proceedings. In some states, a police investigation that does not result in an arrest, in a prosecution, is not considered an official proceeding. In New York, the courts generally have been concluding that police investigations, again, even those that do not culminate in an arrest or a prosecution, are official proceedings. And so the reporting about those proceedings is absolutely privileged. So I'm very concerned that we can overcome the motion to dismiss based upon Section 74 of New York Civil Rights Law, the privilege. In this day and age, if Mr. Smith brings this case, there's going to be a motion to dismiss under the Anti-SLAPP Act, which is an independent source of a fault burden of actual malice. So even
Say that
without
again, it's an independent source.
source of a requirement to prove actual malice. The anti-SLAPP statute broadly defines a class of cases, actions involving public petition and participation. And if your case falls into the definition of that kind of a case, your fault burden is actual malice. The statute is so broad as in the amended form that was enacted in 2020 that it brings within its grasp almost all defamation cases. Certainly a case like this would easily fall into its grasp. And so I think he's going to be stuck with actual malice even without a constitutional requirement, even after a paring back of Sullivan. So
if I'm not mistaken, under our anti-SLAPP laws in New York, if you lose, you pay the other side's attorney's fee.
exactly. So
And that's a huge deterrent. So
Right.
not only do your client lose, he's out paying you and paying the other side's lawyers.
Right. And on top of that, there's a stay on discovery.
Yeah.
And you have to show a high probability of success at the outset without having collected any evidence. The hypothetical goes on, but that obviously could be difficult for any plaintiff. And
yes, it's at the motion to dismiss stage, the traditional notice pleading standard is replaced by a standard under which the plaintiff has to demonstrate with evidence, a substantial basis in law to proceed with the case. It is in effect a summary judgment-like standard at the pleading stage. And it's worse than that for the plaintiff because at the summary judgment stage, you've usually gotten discovery, but here there is no right to discovery before you have to surmount that summary judgment-like test. And the summary judgment burden is flipped over to the plaintiff. So these are a lot of hurdles. And
why would anyone, because I was not familiar with these anti-SLAPP laws as amended by Cuomo in 2020, and they are radically changed the law. It makes it, as you say, it flips the burden of proof on a summary judgment. You have attorney's fee provision. There's no discovery. Why would any liable plaintiff, somebody seeking for misstatements, lies and so forth, ever commence an action in the state of New York? Wouldn't you go to one of the, I think there's 30 states in the country that have anti-SLAPP. Wouldn't you go to one that doesn't?
if we're always looking for other jurisdictions where there would be personal jurisdiction over the defendant.
Is there personal, like back when New York Times Sullivan, they got jurisdiction because 398 copies of the New York Times found their way down to Alabama, and that's how they got them. Today, if the New York Times goes online, every single state, you could sue in every single state. So is there not?
I'm not sure that that's right.
No, that's not right.
There has to be reasonable contact with the state.
Reasonable contact, but it seems like Florida is the choice of the venue of choice.
Delaware happens to be a relatively good choice for defamation plaintiffs. And then the other thing that we always think through is whether we can get the case into federal court. There's an ongoing debate about whether different state anti-SLAPP statutes are primarily procedural or substantive. Federal courts, of course, have to apply their own procedures. And when those procedures are different than state law, federal procedures carry the day. So there are good arguments. It's an evolving space in the law, but there are good arguments in federal court to foreclose the application of all or substantial parts of the anti-SLAPP statute. So if you've got diversity of citizenship, you're going to go to federal court, even if you're in New York, rather than go to state court. But yeah, the hurdles are enormous. And if I'm still stuck with that, what am I going to do? I'm going to argue the Constitution. I'm going to argue that all of these impediments on the plaintiff's ability to bring a case and saddling him with the other side's fees, even if he's got a pretty good case, but he loses it under this next to impossible standard, infringes his First Amendment right to petition. Bringing a lawsuit is an act of petitioning the government. It's petitioning the judicial branch of government for redress. And when you erect all these barriers and punish it with fee shifting without requiring that the lawsuit have been brought in bad faith or was frivolous, I think there's a good argument that the statute violates the right to petition clause of the First Amendment. Now, again, that's an evolving area of the law. Only a few states have struck down their anti-SLAPP statutes on that ground, but a couple have. And New York statute is really more aggressive than almost all of the others. And so I think if any are a ripe target for a First Amendment constitutional challenge, New York statute is that.
A long path. Your
So-
client better have.
Yes, yes. It's.
So there's still.
I don't know
a-
that Smith is the right client for.
There's another
this.
vexing question in the hypothetical. The legislature is now sore as heck at the newspaper. The legislature can designate whatever newspaper it wants to as their official newspaper. And the legislature is now really sore. And they say, you know what? We don't want you guys anymore. Can they do that? Isn't the legislature free to pick whatever newspaper they want and give whatever reason they care to? Does the First Amendment come into play here? Anybody answer
Well,
that?
Judge Trevor McFadden answered that question in Associated Press versus Budowich. It was the case where Trump's press corps banned the AP because they wouldn't officially refer to the Gulf of Mexico as the Gulf of America. And they were punished for their viewpoints. And Judge McFadden, Trevor McFadden, just this year, April of this year, he's a district court judge in Washington, D.C., appointed by President Trump. Trump's been losing a lot of these defamation cases with his own judges, but Judge McFadden said, sure, you have the right to hire whoever you want or put people in there whenever you want for your press conferences, but you cannot retaliate. You cannot discriminate based on viewpoint discrimination. You can't bar somebody based on their viewpoints. That would seem to apply here. Sure, the Courier doesn't have a right to these advertisements in Kendall County, but they can't be deprived of it based on their viewpoints. But proving that is another matter, because they could come up with pretextual reasons. Well, we found another paper is cheaper. I saw this happen in my community. The Democrat and Chronicle lost the Monroe County, the legal notices. That's a very profitable thing. It used to be want ads, right? Was a big, now that's gone. Want ads are gone. The legal notices are still a profitable, my understanding, you know better than I do. It was taken from Democrat and Chronicle by Monroe County, and I know people involved, and I think it was politically motivated, but how do you prove that? Really tough to prove.
Do you
even
think
more
that under viewpoint discrimination, the county would not be free to kick out this newspaper under that federal case?
Yeah, under Judge Trevor McFadden's reasoning, I think the answer is that would be a valid claim.
Under that jurisdiction, but if, let me add, this is, we're getting into the weeds here, but could it vary from state to state based on each state's interpretation of the law under Erie? Isn't there an Erie problem that each state can say, this is our substantive law, this is what we think, and you get a different result depending on the state jurisprudence, no?
Well, when I was speaking earlier about trying to bring these cases in federal court, it's because under
Procedure.
the Erie doctrine-
Procedure. Because the procedure is federal, but the substantive law in the federal court must follow the state substantive law.
Question is, what is procedural and what is substantive?
Right.
And there's an ongoing debate about different
parts of
Okay,
it.
you're.
Yeah, and
about-
First Amendment interests are constitutional and will apply regardless
Right.
of state law.
I'll be
And
sorry.
I think this is one of those really interesting potential 1983 type civil rights claims that could be brought solely on the basis of a retaliation, and one where it'd be interesting to see if there would be a way to expand the notion. And this is something that is kind of out there in the media bar, of whether the press, the reference to the press in the First Amendment has some independent meaning that is distinct from the sort of the broader speech right. But I do think it's an interesting area where it's not a sure thing. The Budowich case in DC is really a forum case where it's access to the forum. The sort of the comparative case out of Baltimore involved the governor. It was also a forum case and involved access to various government officials by reporters, where they were actually barred. Specific reporters were barred, but the news organizations were not. All of these issues get very, very fact specific, and the state law certainly will come into play.
Turn it over to the audience.
Momentarily, yeah. We ought to get some questions from the audience here. Any points of view or questions that you would like to raise here? Because we're getting close to the time when we want to begin to wrap this up. We have an expert panel here. We've gone through a good part of our hypothetical. We haven't gotten to the fact, well, we should just do one more thing here, where in depositions it's revealed that the actual source for the story was, in fact, of course, the ex-wife of the county executive, and that that she was convinced not to file a criminal complaint against her husband, making the case that his political and legal career would be destroyed. Yet the former county executive denies ever being involved in a domestic abuse incident, and the sheriff provides little reliable testimony after he is subpoenaed. So the question is it possible for a prosecutor to initiate charges against a law enforcement officer in a circumstance like that, allegedly dissuading a witness? Would that not be some sort of interference in justice?
Official misconduct?
Official misconduct, you could say?
It could be in a number of areas. It could be obstructing governmental administration. It could be tampering with a witness. And it really is very, very fact specific as to what the circumstances, were and what was involved in the dissuasion. So it absolutely could be. And, certainly that would be something that really impacts the integrity of the justice system as a whole. And I think most prosecutors and most district attorneys would move forward on that because of that. It really strikes at the heart of justice, and it really offends justice. And we would seek to move forward in a case like that if we were legally able to.
But doesn't the clock start when the act occurred? So it's probably
dead in
Yeah.
in this circumstance, at least.
Justice delayed and all that kind of thing. So one more thing then on the scenario. In response to the suit, the Kendall Courier seeks summary judgment, saying its reporting was sound. But the editor gets a threatening phone call from an individual claiming to be Tim Smith. The editor calls the sheriff's office to report the incident. So once again, back to the DA, if the person who is the threatening caller is actually Mr. Smith, what happens next then?
Again, it's going to be very fact specific, and there's certainly charges that potentially could be laid, aggravated harassment involving the phone, and depending on what the threat itself was. So that again is a possibility for prosecution, and it would be very fact specific as well.
But Judge, he's been he would claim defamed. He's again in our post-Sullivan world. You've got a person who years after leaving office has found himself utterly frustrated, and his lawyer is saying that it's just a long road for him to be able to come back. Do you have any solution for such circumstances if we lose Sullivan in this circumstance?
Well, I'm not in the business of giving solutions. I'm in the business of giving rulings. And it would seem to me here, Tim Smith is not going to prevail. I think under this fictitious case, O'Malley versus Sports Dirt, that seems to hold that once a public figure, not always a public figure. And there was actually a case called Wolfson from 1979 where that issue was left undecided by the U.S. Supreme Court because Sullivan dealt with governmental officials when they're governmental officials in the performance of their duties. Butts is the case where the athletic director at Georgia allegedly conspired, there's an article, he conspired with Bear Bryant to fix a football game. And they said, no, he's not a government official at the time, but they said he's a public figure. They extended it. And then in Gertz, they extended it even further to limited public figures. Where people don't even know about, but they insert themselves in public controversy and so forth. But in Wolfson, 1979, it was somebody who was famous at the time, but not anymore. And do you lose your status? That's what this case, our O'Malley case, seems to suggest, that clearly this football coach was a public figure at one point, but he's been in retirement for 10 years, leading a quiet life. And the court, in this case, Supreme Court, in a hypothetical case, that he's no longer a public official, which means he doesn't have to get over that actual malice hurdle. So I would say Tim Smith here, he's been out of office 6 years, living a relatively quiet life as a real estate lawyer. I think it's a reasonable argument to be made that he is like the football coach in a hypothetical. He's no longer a public official, so he gets the easier path to recovery. He doesn't, it's the standard libel law. Now, but truth is a defense there. There was responsible journalism. The one thing that Gertz did that nobody seems to complain about, Gertz did have this limited, expanded public figure, but it also said for private individuals, plaintiffs, you need fault. There's a fault standard. And that's still in place. Nobody, all the criticism of Gertz, and nobody seems, even the conservatives seems to have a problem with that. So here, it seems to me, based on this, the reporter went to Smith and the sheriff and the wife, no comment. He had an audio recording, maybe it was a deep fake, responsible journalism, and he had the actual victim, Miss Smith, say, he did this to me, right? That I would be surprised if he couldn't, I'd be surprised if he doesn't lose on the merits, even without actual merits. I would say that the Courier would prevail based on those facts.
Wow, how interesting.
Can I ask, as a hypothetical editor, can I ask my hypothetical attorney on behalf of my hypothetical reporter at the end of the panel, once we become aware of the content of those depositions, which are explosive, obviously, our reporter is going to be pulling at the leash to report and file a story on the content of those depositions. At what point, what would be the advice of my respected counsel on whether or not we should do that?
Wade back into that water.
Well, as one of the two-handed lawyers on the one hand, and on the other hand, a lot's going to depend on what we were relying on at the beginning and what our relationship was with the source that gave us the tapes in the first place and the information in the first place. Let's say, as part of your hypothetical, that Ms. Smith was in fact our confidential source, that she was the person who gave us these tapes, and that was part of what formed the confidence that we had in the accuracy of the report. Or to build on what the judge just said, it may have helped us establish that at best this would not be provably true or false, because the only two people who would be able to say whether it happened were the two people who were offering differing accounts, which would also be a way of winning on a defamation defense. Assuming Ms. Smith is in fact our source, would she have released us from any obligations that we had to keep her confidential? Did we even have an agreement to keep her confidential in the first place, or was it Was it our decision?
The audio.
Or was it our decision to? Did this land in our laps like the Bartnicki case where the recordings were made by somebody else, in that case illegally, but were delivered to a radio station that chose to air them, and ultimately that was found to be defensible. You know, all of these facts are going to come into play, but I think a big piece of it is also going to be, how do we find out about these depositions, right? Do we find out about these because they happen as part of the incredible morass that follows from the issuance of these search warrants, or do they come out in some part of our defense of that defamation case? All of these are factors that I think are going to be quite important in deciding. And I'll add to that, if it does come up in the context of one of those cases, is there a gag order? Are these under seal? Are we a litigant in the case where these depositions come up? I mean, all of these are factors that, frankly, we need to look at and make an assessment based on those.
I would suggest that if Ms. Smith was actually lying and that Mr. Smith was defamed, so he didn't strangle her and he didn't beat her, his remedy is to sue her. That's where the lie emerges from, and the courier took responsible steps and to verify the information. So I would think that would be where his remedy would lie if he has one.
Can I just make a comment as an elected official in the area of law enforcement? Because I think that, you know, it's important that everyone really understands, you know, the perspective that we come from. And, you know, the reality is, you know, we would never want to see a modification in the law that would have a chilling effect on free press. I mean, the reality is public trust in law enforcement in our communities and in our country is really at an all-time low. And transparency truly is the cornerstone of public trust. And we rely on free press for that purpose. And we embrace free press for that purpose. And it's such an important concept because we as elected officials, we serve our communities. We serve the people that have elected us. And it's important that we have their trust. And we can't have their trust if there is no free press and if there's a chilling effect on free press. So know that from a law enforcement perspective, you know, we really truly welcome free press. And honestly, as a prosecutor, you know, sometimes we're under ethical restrictions from the fair trial side of things, wherein we really truly want to push out more information than we're ethically permitted to do, so that we can be completely transparent with the public. And that is truly an important concept. It really, really is. And we rely on the press for that. So without free press, the system fails.
I certainly thank you for that perspective, and I think that's a great benediction for this program. Judge Rosenblatt and I have been doing this for 25 years or so now, and it always comes out to be an amazing conversation. So thanks to our great panel for making this possible. Really terrific. Thank you.
Okay.
Thank you.
We want to, Rex, we want to have the audience vote?
I don't know, did anybody have any further questions? I think we were.
Some questions? Yeah, Chell, go ahead.
Developments that we're seeing, with the developments we're seeing in AI, how do you evaluate the credibility of your sources when you can have an audio tape of someone who's really not that person?
Really good question.
This was actually the topic of the last hypothetical we did. The possibility of AI being mistaken for reality is increasingly problematic. I mean, ultimately, this is still a craft, a mission that is dependent upon trust and trust in human sources. I don't think that anybody responsible would get an audio tape that purports to be, for example, a domestic violence report, And absent something, absent a human being who will vouch for its credibility as being the real thing, a genuine recording that whether it came over the, the 911 line or was a dispatch that went out to a patrol officer, unless that can be verified by a credible human source as saying, yep, that's the real deal, we would not want to go with it, especially these days, any more than back in the days of just plain old paper and ink. We would want to run with something that purports to be a document revealing a fraud or a blackmail attempt or something like
Hey,
that,
can I
unless
ask
we
you
could
this,
confirm it was real.
Do the media, when they get these potentially AI generated audio video, because they can look tremendously real, they can take your voice, Rex, and make it look like, but apparently from what I understand, there are technological experts who can tell a fake from a real. Do the media, are there technological experts that you can consult to see what they think on these types of videos and audios?
Yes, we haven't found ourselves facing one of those scenarios yet. Diego, can you think of anybody else who has had to do like an AI test for something, a piece of a data that a story turned on or anything like that?
Nothing's coming to mind, and I think the tools are strongest in text.
Yeah.
For checking on these things. But I can tell you from my several years now working as a college level instructor, they don't work very well. And often things that look like they are completely gibberish and have to have been manufactured by a machine are actually written by people, and other times the exact opposite. They don't work great. Images, I know there are technologies that can help identify shadows, and sometimes there are just things that are obvious to the naked eye. But these are very real concerns. Actually, the Wall Street Journal, for anybody who's interested in this particular issue, yesterday did a video report where they played a 10-minute movie that they made using nothing but AI generating tools. And it is not bad.
What else? Anything further?
Hi, I wanted to say thank you for this panel. It was very informational, but I do have a question on maybe your opinion on the impact of the ability to prosecute based on maybe a change in who's considered the press, especially in the age of social media with TikTokers and people on Instagram or YouTube who consider themselves journalists, who report these stories as journalists from maybe the Herald or another news source. Do you think there's any impact on your ability to prosecute them as members of the press?
Yeah, in an age when anybody can claim to be a journalist, when in fact they might be an activist, they might be a crazy person. Yeah, I mean, those are very real questions, and we live in a country where journalists are not licensed. That is one of the necessary, that's a foundational aspect of the free press, that the government does not say who gets to be a journalist. And that means that it is the marketplace of ideas that ultimately assesses the value and the credibility of the news organization and the people who work there. And amid the digital wonderland, that has become somewhat scrambled. In other words, there is a difference between a credible journalist and a popular influencer, and questions of who's trusted versus who is influential are one that we are grappling with, and it's part of just as law enforcement is one of the many public institutions that faces a diminution of public trust right now. That is part of the reason that journalism, I would argue, is facing that as well, because in an age when everybody has a printing press effectively in their pocket, it is sometimes hard for journalists to compete.
I'm
I mean,
sympathetic to police officers who might be in a situation where they are asked to clear the premises of illegal occupants, for example, and they may think that they are arresting someone who is illegally present and they sweep up a reporter in that. However, it's incumbent upon the reporters in those circumstances not to be posing as demonstrators in order to gain the trust of the demonstrators, perhaps. And if you do that, you do risk being arrested, and you don't then have the protection that you ought to have as media. I think of the demonstrations at Columbia University, where the brave student journalists who went in to cover that made themselves 8.5 by 11 laminated cards that said great big on their chest, "Working press," so that they wouldn't be arrested along with the demonstrators. The journalists thereby forfeited the access that they might get to the demonstrators by being mistaken as one of them, but they protected themselves from the potential for being swept up in the event that there was a law enforcement action. So you can see it, and it gets difficult, but it's again one of those sword and shield things. If you're a journalist trying to be a part of a story, you have to risk being a true part of the story, and thereby you don't necessarily have the protection that journalists ought to have to pursue their work. Over here.
So does anybody have a prediction as to whether New York Times versus Sullivan is truly in jeopardy and could be overruled in the near future?
I spent a lot of time on that, and this is a world that my panelists here, fellow panelists, is probably much more informed, but I've spent the last month caring for this and reading everything imaginable. And when I started looking at it, I thought it was in jeopardy itself. I've come to the conclusion now that it's highly unlikely that the public official actual malice standard of Sullivan's going to get overturned. There was a case from Colorado, Counterman, from 2023, June of 2023, where Kagan wrote the majority and endorsed Sullivan. The opponents of Sullivan always held out hope for Kagan because she wrote a 1993 law review article, 1993 in a Chicago journal, that she questioned the extension of Sullivan to public figures and so forth. She wrote the majority. Concurring in that was Gorsuch. A year earlier, he dissented on a cert application in a case with arms dealer. He and Thomas dissented, so there were two. It was always Thomas used to dissent on the certs publicly. Gorsuch joined him with, he essentially copied the law review article, which is highly questionable facts in there. But Gorsuch even endorsed Sullivan in this Counterman case. They just denied cert in March. Steve Wen had a case that the conservatives had their hopes on. This is the one. They didn't get any public dissent on that, not even Thomas. I do think perhaps because the conservatives, if you look at the verdicts, there's been a movement from the Federalist Society and the Claremont Institute here. You see all these things, and it's they say it's too hard to win if you're a public figure, too hard to win if you're a public official, the bar is too high. Well, we've seen a lot of large verdicts. Fox News got hit for $787.5 million by Dominion voting. Alex Jones got hit by almost $1 billion on the Sandy Hook. Donald Trump got hit with $83.5 million from E. Carroll. I forget her name, but she was Jean. Yeah. We've seen the Dean of University of Virginia won a case against Rolling Stone. Got $3 million. Amber Heard and Johnny Depp. There's a lot of victories here. So, and conservatives might be careful what they wish for here, because if the bar is lowered, there's a lot of conservative journalists out there, and perhaps the president or two saying some mistruths out there, and that they may be the victims if it is. But I would say, in short, if it's not going to get overturned, but it may get peeled back to take away this public figure doctrine, to limit it to public officials or really famous public figures, not these limited public figures. That'd be my guess.
I tend to agree, and I think the composition of this court, it seems highly unlikely that there would be 4 votes to actually hear a cert or take a cert petition on Sullivan at this point. And I think if there were one, it's the only clear vote is Thomas. And his relative silence recently, I think, may suggest that he's decided there are other things for him to spend time on. I also agree, though, that the most complicated piece of this is the public-private figure element. And I think the case, the Time v. Hill case, which is, again, one of these cases from the late 60s, early 70s after Sullivan, that wasn't really a defamation case. It was really a privacy case, but incorporated actual malice, is worth taking a look at. That case involved a Life magazine story about a play that was based on a horrible home invasion and a hostage taking that took place in, I think, in White Marsh, Pennsylvania. The events were sort of very loosely the basis for a play, but not, the playwright had actually said that it wasn't exactly that story. For some reason, the profile about this play involved photographs at the home where this home invasion had taken place, and the family sued, alleging an invasion of privacy, and ultimately the actual malice standard was used as a way to beat back that case. Richard Nixon was actually the lawyer who was prosecuting that case at the time, and he famously was quoted in one of his many tapes as saying, "Well, I knew they'd never let me win on a defamation case against the press." Even though it wasn't a defamation case.
He blamed Sullivan for Watergate.
And he blamed Sullivan for Watergate, too.
I think a question, Diego. If the American public were understood Sullivan, maybe each person in the United States spent an hour trying to understand it, would the American public overturn it or keep it?
I think people would struggle with who, I think people would struggle with exactly this point. Who can claim it, right? And which are the cases where we're going to be able to claim actual malice? But I guess one of the things I suggest to people when they're not sure whether the defensive protections that exist are worth it, what I suggest to people is that they look at all of the things that they've posted online, and they think about whether any of those might well lead to a defamation case, and whether, they're not going to get sued because they're not deep pockets, but could it lead to a viable defamation case? And I think when people realize how many things are said by them in a context where they don't think they're actually going to get sued, it might actually lead to a defamation case. I think they see there's some real value in having these sorts of protections. I also suggest that people go back and look at what Madison was actually writing about at the time that he was initially thinking about what the First Amendment meant in those first 10, 15 years of the Republic. Particularly in opposing the Alien and Sedition Acts, and the importance that he saw in having a robust public discussion. What DA Parisi said earlier about the importance of transparency and trust. I mean, these are all fundamental pieces of the system working, right? Everything needs to exist. We like to think that it's going to be somewhat restrained and honest, and most of the time it is, but we need to have that flexibility, that breathing space, to have some things that maybe are on the edges.